webinar, Adjudicating Major Crimes in Tribal Courts with the Fort Peck Tribes. And as a reminder, we will take questions at the end of the presentation, but feel free to type questions into the Q&A box as you think of them, and we'll get to them at the end of the presentation. And I'd like to first introduce our presenters today. So we have Jermaine Jackson. He serves as the Court Operations Analyst and Terminal Agency Coordinator Point of Contact with the Fort Peck Tribal Court. He is a combat veteran and graduated from Montana State University Northern in 2020 with a bachelor's degree in criminal justice. Prior to going to college, he served as a police officer with the Fort Peck Tribes Department of Law and Justice. Since 2020, Jermaine assisted the Fort Peck Tribal Court with the implementation of Special Tribal Criminal Jurisdiction VALA 2022. He currently manages various criminal and non-criminal justice users for the Fort Peck Tribes Tribal Access Program. We're also joined by the Honorable Stacie FourStar. She is an enrolled member of the Fort Peck Assiniboine and Sioux tribes of Lakota, Nakoda, and Hidatsa descent. She received her Juris Doctor from the University of North Dakota School of Law with a certificate of specialization in Indian law. She has served as a prosecutor for the Fort Peck Tribes, an associate judge, and currently holds the office of chief judge for the Fort Peck Assiniboine and Sioux tribes since 2015. And with that, I would like to turn it over to Judge FourStar and Jermaine.
Good afternoon, everybody. Thank you for joining us today. Adjudicating Major Crimes in Tribal Court. This presentation today, Jermaine and I have actually done this presentation once, and there was such an interest in it that we wanted to be able to share it with others. And also for the end of the presentation today, we'll have time for questions. So we would also like to learn from you as well. And for the slide, our picture again. So this is the roadmap for today. We're going to do an introduction. At the very beginning, there's several slides. We're going to talk about Fort Peck so you can get a feeling of what it's like here, the people, the makeup of the tribal court, how big we are, the communities that we serve, and then give you a small overview of our tribal codes. And then we'll move into some case studies. There's a couple case studies that we're going to go in depth, and throughout the presentation we're going to refer to a certain areas that we want to cover with those that are either implemented VAWA 22, looking at implementation of Special Tribal Criminal Jurisdiction, or looking at TLOA, the Tribal Law and Order Act, for the enhanced sentencing. Jermaine is going to go over some statistics of our jurisdiction, and also talk about the Tribal Access Program. I'm going to talk a little bit about the Tribal Access Program throughout the case study, but Jermaine will give you the meat of that conversation. Next slide. So Fort Peck Indian Reservation, located in the northeast corner of Montana. So it is the plains area, rolling hills, Missouri River, Highway 2 goes across our reservation. It's 110 miles long. We have Badlands. We don't have the mountains here on this side of Montana, but beautiful, large land base. So within this land base, we cover 4 counties, and we have them listed here on the PowerPoint. But the 6 communities that we have 2 larger communities, Poplar and Wolf Point. Then we have the smaller communities that are surrounding the middle of our reservation is Tule Creek. We kind of call that the east end, west end of our reservation. So our law enforcement, it is tribal law enforcement, 638 program, currently about 22 officers. They also have a narcotics officer, 2 dogs, drug dogs, also have a criminal investigative division. But the interesting thing, and what most tribes may not be familiar with, is cross-deputization. So our cross-deputization program includes those entities that are listed on the PowerPoint, which are deputies, troopers with highway patrol. We do have FBI that comes here. They are located about an hour away from the reservation. They have a station there. So our cross-deputization agreement, we give authority to law enforcement that are not tribal law enforcement to have arrest authority, investigate over Indian persons. The deputies, the troopers from the state of Montana gives the tribe authority to do the same for non-Indians. So this is prior to implementing VAWA on our reservation. We've had this agreement in place since 1999. So they give us, our tribal officers, authority to arrest non-Indians as well. Next slide, please. So this is just to give you if you're not familiar with Montana, there are several tribes that do have a large land base. So if you see in the upper right-hand corner where it says Fort Peck Indian Reservation, Roosevelt County primarily covers the reservation, and it is actually the county. Wolf Point is the county seat for Roosevelt County. Next slide, please. So this is the Fort Peck Tribal Court. Located in Poplar, Montana, this is the agency. Most of our tribal employees are located. Our tribe does employ anywhere between 600 and 700 people. The court itself, established through legislation through our tribal executive board in 1965. We've grown a lot since then. We've become more than just the clerk and a judge. We do have 4 judges, 1 chief, 3 associate. They are elected. The election of judges occurred for the first time in 2015. We have 2 types of enrollment. This may be unfamiliar with a lot of those individuals that have enrollment as part of their tribe's membership. So we have enrolled. They're considered 1/4 or above, and those are the fully enrolled members. And then we have an associate membership. They are at least 1/8, but not quite 1/4. So our associate membership is there for the purpose of Indian health services. There are some other, maybe hunting, fishing. There are some other reasons why we have an associate membership. But our total membership, it's over 13,000. And that number does include our adult and juveniles. So about half of them live on the reservation. And our reservation is about half Indian persons, half non-Indian persons. And SORNA. So SORNA was implemented in 2011. It was through the Adam Walsh Act. Our SORNA office is actually under the court as well. So is our probation. That's a little different than other jurisdictions as well. But we did implement the Tribal Law and Order Act here and VAWA 13. We were a pilot tribe in 2015, one of the 5 pilot tribes. So we have been implementing and practicing under VAWA since that time. So it's been 10 years. Next slide, please. And this is the makeup of our staff that we have here. We apply for grants, a lot of grants. And I think since 2017 to current, we've probably applied and received about 10 million in grants. So a lot of our services that we provide on-site from the court are through grant funding. We have the prosecutors, public defender's office. They are not in the same building as us, neither is probation or SORNA, but we all are able to work together as a group. And this may or may not work for your jurisdiction, but we are able to do trainings as a group. We had most recently, Jermaine put together a mock trial for us last week, actually, and it went well. So for those of you that maybe you don't have trials as often as you would like, and talking about major crimes, when those trials come, there's a lot of work that goes into those. So that mock trial may be an option that you want to look at, and bringing in your actual law enforcement, some of your witness and mock jurors. Jermaine actually came in under a special jurisdiction when he came to us, but we do have a active healing to wellness court, and some of the other programs that we have on here that you see, we've applied through those for CTAS grants and other grants. Next slide, please. Just a continuation. We will have it at the end, but fptc.org is the link to our code. We talk about the criminal offenses that we have in here. It has expanded. We still have a lot of work to do so 1965 to now, and laws change. We've made amendments to our code, but there is a lot more that we want to do. And a lot of the work that's done at Fort Peck is done in-house, meaning that there isn't money that's set aside or applied for when we talk about code revisions. There are people that do that, the legal department for the tribes that are already part of, they're not specially hired. So when we talk about doing our codes, a lot of this work is done in-house. We are a court of general jurisdiction. We hear everything here from misdemeanors to felonies. Next slide, please. So the next two slides, this one is just the enhanced punishment. So just to give you a look, this is what our code looks like. Under Title VI, part of the trial proceeding, when we're talking about TLOA and we say enhanced punishment, this is what our law looks like in our code, and giving the information for the expansion of beyond 1 year, beyond the 5,000 limitation under ICRA, talking about the council, the judicial requirements. Next slide. Trial proceedings. This is just section 512 of Title VI, another part of our criminal procedure. And if you look at the very bottom, so if it says, as per resolution, gives a number, you look at the date on there, 2012. So in our code, if you go through some of our criminal offenses or you're looking at our procedures, you can see the last update that was done on it, if there was an update done. If there's no update done, then that means that's probably the law that was originally there. Next slide, please. Okay, so case study. This is primarily what I am going to talk about is when we're talking about adjudicating major crimes, the next slide's what comes with that. And the cases that I'm going to use to talk through some of this is one with a 23-year-old male and another one with a 21-year-old female. And look at this one, the 23, just to give a little bit of the backstory. The male was charged with manslaughter, reckless driving, driving in a field with other individuals in a vehicle, in the back of the truck, essentially joyriding. There was no, the driver actually, there was no alcohol involved and he wasn't under the influence of anything. And the female, teenage female, she falls out of the back of the truck and she hits her head. So this happens July of 23. He does have a bench trial. He elects to have a bench trial. And in March of 24, so a little over a year ago from today, he is convicted of the manslaughter charge. There are several issues that were sent to appeal. The appeal, if you go to our website, you can look it up. It's Appeal 871. But part of that appeal, there were multiple agencies involved with this. So there was the local tribal law enforcement. There was the criminal investigative division of the tribes because there was an unattended death on a reservation. The FBI came, and highway patrol because there was an accident, a motor vehicle accident. Highway patrol responds as well. And I believe that county responded as well. So all of these agencies and who's taking charge, and that's worked out between law enforcement, but also as part of our cross-deputization. There's an understanding of the type of crime and who is taking charge of that investigation. And the other individuals that were involved. Some were juveniles, some were adults. And once he was charged, and he was actually he didn't have any prior convictions. I believe that he did have a traffic offense, but nothing major. So when he comes, and the prosecutors, now they have to decide what are they going to charge with. And if we are going to do any type of enhanced sentencing, now we have to be concerned with counsel, right? We have to give that individual counsel. We do have a public defender's office, and we also have the ability to hire attorneys outside of the public defender's office if need be. So I'm going to talk a little bit about this case without moving from the slide. And I'm looking at the issues that were filed on appeal. So the evidentiary issues, because Highway Patrol had come to the scene, they do a crime scene crash site. They have all of this investigation. So through the discovery process, there was unsurety about whether that specific crash form was shared or not in discovery. So there was motions filed. A motion in limine was filed in regards to the evidentiary matters. And there was also an issue with evidence that the FBI may or may not have in their custody. And for those of you that have jurisdictions where you are concurrently charging, or you are making that decision whether you're going to charge tribal, charge federal, or both jurisdictions going to charge it at some point, and working through that. So with the Fort Peck Tribes, because our code gives us a very short time frame, we have arraignments Monday, Wednesday, Friday. So at the next available arraignment, that decision in that filing has to be made, whether it's the charging document or requesting a probable cause hearing, but they have to move on it quickly. So with the information that they have, we know that evidence may or may not be available, may or may not be able to be processed. And taking all of those determinations, taking them into consideration. So there was the Highway Patrol, the FBI, the criminal investigator, and also taken into consideration, once that individual is charged because a life has been lost, is there a threat to the community, to the public, is the family upset? Is the defendant, is there a safety concern there? And being able to do all of this within a matter of 48 hours, sometimes 72. So with this case, some of the interesting things that came about is, at the end of the trial, there was evidence that was alleged to have been by the defense, that it was there but not made available. So that's one of the issues on appeal. And there's also the finding of sufficient evidence. Was there sufficient evidence beyond a reasonable doubt to convict? And that was based off eyewitness testimony, and also the issue of the Highway Patrol not having the crime scene available, and whether the trooper was going to be allowed to testify or not to it. And the last one, which is proving the appellate's Indian status. And this is something that's been more recent that has come up. It wasn't part of the motion in limine. They didn't stipulate to it, but at the very end of the trial, they bring it up. And I believe it was in closing. And so, the appellate court ruled, it wasn't part of the argument at the beginning. So those arguments about an Indian person, what is an Indian person? And everybody has different opinions within their tribal courts over that. So if you have any interest in that, you can look at our appellate court. We go into it a little bit more specifically about whether or not you're enrolled, the degree of Indian blood, also Canadian, because we're so close to Canada. That is appealed a couple times now that I can think of, where we've gotten somewhat of an answer on it. And with the male, at the very last bullet there where it says a traffic offense in January 25. So his conviction was upheld. The federal government decided that they were not going to take the case, even though they did have evidence that they were processing. And this is where it becomes a matter of what is available for the lower court, what is available for the trial court to be able to use, and does it or does it not put the defendant at matters of appeal and working through those. So in this matter, he was sentenced and there was no civil suits that were filed in regards to it, but our jurisdiction does allow up to 3 years for those filings. But he did come in after for a traffic offense, and he had a no driver's license. So in January 25, and at this time, he is, I believe he is still on probation, and he comes in, and I happen to be the judge on it, and I asked him about the driver's license. Because of the manslaughter charge, he did have some traffic matters that were involved with that, but his license was valid at the time. So when he comes in this time in 25, his license isn't valid, but he tells us that, well, my license was suspended. I had to pay some fines, but I paid those, and now I should be able to get my license back. And he still had a hard copy of it, but when it was ran, it was coming up as not valid. So what we learned from that is, between Jermaine and I, and Jermaine being able to run that in TAP and checking it, his license was not valid. Yes, he did pay the fine, but he didn't pay the administrative fee to have his license reinstated. But we look back at the crime, what is this? Why was his license suspended? And it was good in July of 23, but now it wasn't good. So he was on conditions of release, during the period until the trial, and then he was sentenced and he was on probation. And never did it come up that there was anything that he should have reported. And we find out that he, shortly after July of 23, he got a DUI in another jurisdiction, off the reservation, but within the state of Montana. He got a DUI, but that would have played into his stipulations had we known at that time. And we weren't checking it in TAP. We didn't run him in TAP at the time when he was on conditions or on probation. So we find out he had the DUI, and that was the reason for his license being suspended and having all of these issues. So the lesson learned was utilizing TAP for conditions of release, utilizing it for the probation or parole status, and whether your jurisdiction is going to allow you, how you have it set up to use those. If they're off jurisdiction, is there a way for you to violate or the conditions that they have, and how you want to utilize that? For us, we would use that in our jurisdiction if we knew that they had received any criminal matters in any other jurisdiction besides ours while they're on probation or parole. The next case with the 21-year-old female. So the focus of this one is more on the concurrent jurisdiction and how that plays out in Fort Peck. So with the stabbing of her paramour, it was actually her ex-boyfriend, but they did have a child in common, and he did have another girlfriend at the time that this happened. And she was charged immediately, arrested and charged in the tribal jurisdiction. She did sit, and then she entered a plea along with the public defender. She entered a plea to aggravated assault. It was a lesser offense, but she, for whatever reason, the feds did decide to take this case, and I believe that there was some evidentiary matters with it, but she changed her plea to the aggravated assault in December of 24. And in the very next month, they do take her, she's indicted, they take her into federal custody. But with her change of plea and the aggravated, so sometimes the defendants, if they have the public defender and the or counsel working on their case, they may plea to either a lesser included charge or they may reduce it, but it plays into whether they go to trial or not and what is on record. And if you are working with your U.S. Attorney's Office, your assistant U.S. attorneys, that does matter. It matters if they're going to go to trial or not, what it has been stipulated to, what's been put on a record, what is the witnesses, what is their credibility, what is the availability of them. And the next slides, I'm going to just go through as when we're talking about the major crimes, these are the things that we want to look at. Next slide, please. Talking about the case preparation. So we all know that everybody has their roles. Law enforcement, prosecutors. What we have here are some of the things to consider. We do have telephonic search warrants in our jurisdiction. I know some jurisdictions don't do that, but for us, because of the land base, the space and the evenings and weekends seem to be a lot of action go on during those times. Telephonic search warrant works for our jurisdiction. And it is part of our cross deputization. So it's not just tribal law enforcement doing these, it's all entities. And the prosecutor, there was a webinar that was given just yesterday on victim rights that when we talk about ICRA, in the next slide, we're going to talk about rights. One of the things that Fort Peck has recently implemented is the victim rights. It's not that it didn't exist in customary or in common practice, but having it codified does make a difference. And having the entity see that we have to keep all of these in mind when we are going through witness prep, keeping witnesses informed. So the prosecutor role, huge, and a big part of law enforcement and prosecution is discretion. That discretion that the individuals are using. These entities for us in Fort Peck, they all work closely together, and they work closely with the state and federal entities. So some of you may be familiar with MDT, the multidisciplinary teams. Fort Peck does this on a monthly basis, especially for those major crimes that involve children. Next slide, please. ICRA considerations, talking about those fundamental rights and making sure that you have those in place prior to implementing is huge. It's a must, but also even if you're not implementing and you have major crimes, you have felony jurisdiction, looking at those and making sure that you are establishing the precedent, talking about excessive bail and fines. What is excessive? And your jurisdiction may have a different interpretation of that than any other jurisdiction. Ours has been interpreted inside of our appellate opinions as well. The right to a jury trial. We did change our code to give that right to a jury trial as mandatory when it involves non-Indians. But we also changed it for one of our codes, partner, family, member assault, giving that jury trial to the defendant, no matter Indian or non-Indian, to be fair, but also to be consistent. Exhaustion of tribal remedies. This habeas is part of this now, exhausting that tribal remedy of the habeas. If you have them filed in your jurisdiction, we have had them filed, but they haven't gone past our appellate court. Next slide, please. So some of the things I talked about with evidentiary concerns, knowing your jurisdiction's capabilities as far as lab times, processing of crime scenes, who is going to testify to that, who has chain of custody, who has control of your evidence. And the multi-agency is probably the most, concerning that we have, because we want to make sure that we're able to prosecute these crimes and that we are giving everybody the time frames that they need. At Fort Peck, it is rather quick, I would say. So we do have an appellate opinion. Speedy trial for us is 1 year from the date that the charging document is initiated. But in our code, we have a 180-day rule that we have the initials, the pretrial happens within usually 4 weeks, 6 max, but within 4 weeks. And that seems like a really short time frame, because that's when they're setting the discovery deadlines, the motion deadlines. And then between the pretrial and the trial, you're going to have more than likely less than 6 months. On the federal side, they have 6 months to get that through. It's almost the same in tribal court for us, but speedy trial is 1 year for us. So we do have that time. So knowing what evidence you have and how long it's going to take to be able to have that in court if needed. And preserving issues for appeal, that is a big one for us as well. And knowing that process in your jurisdiction, so we can get those answers that we need to the questions that we have. Next slide, please. Jury considerations. So the jurors for our jurisdiction, we have chosen to use the voter registration. And this was an agreement with the counties that encompass our reservation, that they would give us their voting information. We would share our information with them. And this is how we are able to serve non-Indians for our jury selection. We have both Indian and non-Indian for the special jurisdiction. We have Indian for the tribal defendants, and that can be different. Other jurisdictions may have Indian and non-Indian for all jury trials, and it's really up to how your tribe wants to handle those. So for our jury selection, we have a lot of individuals, over 13,000 that are enrolled. If we're using our enrollment to pick out jurors, we have to know which ones are within our boundaries. So however you narrow that down, we narrow it down by addresses in the database. Next slide, please. Okay, qualified judiciary. This is for the VAWA Taloa special jurisdiction. For our tribe, we do have a qualification to be a sitting judge, minimum qualifications to be able to get on the ballot. We do have a tribal bar exam. It's given twice a year. You have to pass the bar to be able to sit as a judge. We do have law-trained judges, but we have a consideration that's a little different than a lot of other tribes. Law-trained can be interpreted in Fort Peck Court as an individual who has the experience and education and may not have a law degree, may not have a JD, but does have a degree, bachelor's, master's, and can pass the qualifications. There's a bar exam and a judge's qualifying exam. So when we became a pilot tribe, that's what Fort Peck did, is we had actually applied to DOJ without having a sitting judge with a JD, and it was approved. Reason why I put that out there is I know there's individuals that are worried about what is a qualified judge and how do I get that in my jurisdiction if we don't have access to that. We've also had pro tem or specially appointed judges if needed in those instances. Next slide, please. So this is the last slide I'm going to do before I hand it over to Jermaine. This is what it looks like for Fort Peck. There are some changes here and there, but essentially our arraignment is within 48 hours of that arrest. And for us, it could be concurrent charges, both investigations going at the same time, deciding what evidence can be shared, what's accessible to the tribe. And then we have our pretrial, and then we have our trial. There, anywhere within this process, the feds could step in at dismissal, at conviction, at acquittal. But generally, we know, not the judge, but the tribes know, because keeping in constant communication if the feds will step in and when that will happen. And sentences may be concurrent. We've sentenced people on the tribal side, on the federal side. Sentences may run concurrent. Sentences, we work with both entities to figure out what is going to be in the best interest of the tribe as a whole when we sentence the defendants, and also keeping the victims informed as well. If you look in our code, we do have a notification to a victim at certain process of the defendant's trial or release. And that notification is part of the safety factors that we have with non-Indians and Indian defendants. Okay, I'm going to hand it over to Jermaine.
Thank you, Chief Judge. Good afternoon, everyone. My name is Jermaine Jackson. I'm a court operations analyst for the Fort Peck Tribal Court. You can do the next slide, please. I've been working under the OVW Special Tribal Criminal Jurisdiction grant, and I've been a part of it for about 5 years. And in my portion of today's webinar, I wanted to talk to you about our process, a little bit of our history, some of our issues when using the Tribal Access Program to share records with national criminal justice databases. Next slide, please. A little bit more about what I do as a court operations analyst. Pictured here is a near current VAWA report from the Fort Peck Tribal Court. Many of you that are a part of ITWIG, you hear these reports given by us each year when we attend the ITWIG meetings. This is a little bit different. It's going to be different this much. We just had a VAWA case, but you guys will probably hear that at the meeting this later on this month. As a court operations analyst, I work a lot with data. The numbers you see here and in the next slide are some of the things I do for the court, and you'll learn how it ties into NCIC, or the National Criminal Information Center. Next slide. Okay, this data was taken from a total of 2,409 criminal cases and a total of 556 highway offenses received by the Fort Peck Tribal Court in 2024. I didn't put these crimes lowest from highest, but you can really see where the problem areas we're having on the Fort Peck Indian Reservation. And I know when it comes to data, there's usually a lot of questions associated with it. You know, as Chia mentioned earlier, there'll be time at the end of the webinar and on the Implementing Tribes call tomorrow for any questions that you might have for us regarding what you see here. Next slide. Okay, so a bit of a disclaimer, you're gonna hear a lot of acronyms throughout this webinar. And just to make sure that everybody's paying attention, there's gonna be a little test afterwards for every acronym mentioned. So just to make sure everybody's watching. So what is TAP? I know a lot of ITWG tribes utilize the program, but for those uninitiated, TAP stands for the Tribal Access Program. It allows tribes to share and access information for criminal justice purposes with federal criminal justice information databases. See, that's a lot of acronyms. I've been with the Tribes Point of Contact for 4 years. We've been sharing felony court records for about a year now, and we've been sharing protection orders since I've been the POC. A little bit of history on TAP. 2017, the Fort Peck Tribes became a TAP full tribe. TAP full means that the tribes have the ability to access NCIC and the ability to conduct fingerprint-based background checks on a kiosk that the Department of Justice deploys to the tribe. Few years prior, we had just implemented the SORNA and the SORNA Act into our CCOJ along with TLOA and VAWA 2013. So this history was way before my time working with the court. kind of a little bit of a story here. Our prior POC, or point of contact, left in 2021, and every month we have these tribal justice coordinating committee meetings. And one day, you know, I happened to go to one of these meetings, and you know, the POC kind of announced his departure from the court, and you know, this kind of meant that the tribal access program had to go to somebody else. And you know, I think it was because I'm a millennial and I'm good with technology. You know, everybody, all the fingers kind of pointed to me, so I was really voluntold to manage this program. Since 2021, we went from 3 users to over 30. So, you know, I kind of took this program up from 2021. Next slide, please. This is the hierarchy of our agency's ORIs. They're called originating agency identifier. So every ORI has a role in TAP, from law enforcement conducting investigations to corrections, conducting bookings, to the court entering court records. So Chief Judge's resume is quite long, but what it doesn't have in there is that she's also the administrator of the travel access program. We didn't have enough room in the email to put that in, so we kind of left that one out. Next slide, please. Here are non-criminal justice ORIs. In 2017, before our prior POC left, Human Resources and SORNA were the only departments utilized in the travel access program. HR actually had control of the program, and they were only using it for background checks on employees. When I started to manage this program, I didn't know what TAP was. Around this time, a new business relationship manager, they call them BRMs, another acronym, was assigned to our reservation, and he schooled me on everything TAP. And one of the things that I learned was that tribes fought for this ability to access criminal justice information. Before, we would have to get states to do it for us. And the SORNA Act and VAWA 2022 actually allows this within its legislation. So I really, with the information I learned, I was like, we can do so much more with this program. We don't even know it yet. You know, it was kind of underground. You know, nobody really had much knowledge about it. From my past experience as a police officer, TAP is everything that an officer could want in terms of investigation. We really don't have to rely on dispatch. We could access everything on our laptops, on the web, because it's a web-based program. As a court employee, TAP allows us to know what kind of history a person has pre-sentencing and post-adjudication. Being the pesky grant coordinator that I am, I started knocking on doors of departments who were initially involved with the program. Once I started getting support, me and the chief judge really rose that program from the ashes. So in order for a program to improve, you really have to have problems. One problem that affected the use of TAP over the years was accessibility. The kiosk was located in our law and justice department. SORNA couldn't take offenders in that room because social service was right down the hallway. We wanted to move the kiosk to the jail, but HR didn't want to take the employees to the jail. Second problem was past council administrations did not want to share our records with the FBI. And you know, that it's fine because it's part of, you know, tribe sovereignty, but that can be a biggest barrier for any tribe, you know, trying to get their travel access program off the ground. In 2023, TAP and HID developed mobile kiosks to deploy to the tribes. You know, it was then that I figured that it would be, you know, that would be the end of our accessibility problem. And at the same time, like, we just had an election, so why not try to get council support on this? Next slide, please. So in 2023, I and the chief judge gathered all the agencies and got them on board with sharing felony dispositions with NCIC, because major crimes, as you can see in the data provided earlier, they were increasing, and we saw that on our reservation had an increase in sex offenders moving into the area. Drug crimes, violent crimes were happening. Not only did we see it, but concerns were also being raised, by and to this new tribal administration. We knew that getting approval from the council was a problem before, but we just wanted to say, well, let's just make sure that they understand that it's just going to be major felony crimes. And when I took this resolution at council, it was like it was crickets. They didn't know what TAP was. They were worried about petty crimes and employment barriers, but my argument was, going back to those concerns over public safety. Once they saw the list of crimes we wanted to share with NCIC, this resolution was passed. Next slide. So some of these crimes that are listed on here, and you can tell there's a lot of major crime. These are the records that we share with NCIC. Next slide, please. Give everybody a little bit of moment just to kind of look through those. And next slide. So my ultimate goal with the travel access program was having a complete process wheel where every one of our partners in the criminal justice system is using it. Law enforcement utilizes it as an investigative tool. Corrections books and photographs inmates. SORNA registers sex offenders. Prosecution can conduct a name-based criminal history check on a defendant to be used for discovery. They can also make pretrial release recommendations. One of the things that I do for our court is I enter permanent orders of protection, which prosecutors can also do in addition to checking if they're a registered sex offender. I think, when we started doing this, I had to backlog about 5 years worth of protection orders, and that was a crazy experience. The probation office utilizes TAP for pre and post sentence investigations to ensure their clients are not violating conditions of a court order. Next slide. So every tribe is a little bit different. I know, I mentioned the barriers earlier, and one of the barriers is, being able to only enter certain records into NCIC. Normally, the question that was raised with council was everybody having a FBI number associated with an arrest, and that's what happens with TAP is FBI number is always associated with an arrest, and the possibility of a case getting dismissed, which kind of happens frequently. Normally, every inmate that goes to jail gets printed and the record is entered into NCIC until the court enters the disposition. We're a little bit different. We wait for the final adjudication and then send the record up because, like I mentioned earlier, we're kind of treading on I think the hope is to just fingerprint everybody, and that would just kind of take this whole barrier away. Next slide. So some of the success stories that we had, you heard Chief Judge kind of talking about the case with the driver license. That was, something that, any tribe can benefit off of using a travel access program. Last year, I think it was last year, we had a VAWA case, and the female that got arrested, she claimed that she was white, and we did a criminal history check on her, and it turned out that she was Native American. So that was something that could really help. We had a male that had an outstanding warrant for murder in a different state. SORNA, they were able to identify a sex offender who spent years living on the Fort Peck Indian Reservation without registering. We entered a tribal warrant for escapee, and he was later found in Missoula, and he was extradited back to the reservation. And like I said, as we continue to grow in users and usage, these success stories will continue to be, to grow. Next slide. So, if anybody has any questions, our email addresses and contact information are on the top. If you ever need any ideas to help your program grow, feel free to give us a call. We have a QR code that will give you access to our presentation, and we also have a QR code on the right there that will give you access to our comprehensive code of justice. I know this will really be beneficial for tribes that are just now implementing STCJ. So we have a little bit of time for questions.
We have one question here in the chat, Jermaine and Judge FourStar, from Shelley Harrison, Chickasaw Nation, Office of Tribal Justice. She asks, does your code make Indian status an element of the offense?
So it does not, but with the cases that have gone up to the circuit court, specifically 8th and 9th Circuit, it's come in the lower court here more often, but it does say in our appellate rulings, right, that's an element of the offense, but it doesn't state that in our code. So is that implied by the appellate court, or is it because that is part of, and it's recently started after we had implemented special jurisdiction, is that these arguments have come forward. But to answer the question, no, it's not in the code. And another thing that's in our code is Indian person. And I think that's why, because it's open, right? We don't say in person enrolled in a federally recognized tribe. It's not specific, it's Indian person. And a lot of times the test is used of bringing in the circuit court cases and using that test to determine whether or not that person is Indian, but those are preliminary matters before trial. I did see another question there from Janie Schroeder in regards to the female that we were talking about that was taken into federal custody. The question was, would she return to tribal custody? So she may or may not. And that was one of the matters that, so once they go into federal custody, if they still have a sentence that they're serving, the prosecution sometimes files to say, okay, we're gonna hold this in abeyance until her matters here are adjudicated in federal court. So if she is acquitted, the release on there does say that she must return to tribal jurisdiction upon her release from federal jurisdiction. So they would transport her back, and then she would continue serving her sentence. If she was convicted in federal court, they would sentence her, and then the two entities would talk and say, okay, are we going to leave her sentence in abeyance, let her finish that, come back and finish this, or are we going to give her credit for the time that she's serving over there? And a lot of times, if they are serving a federal sentence, we get the public defender's office asking us to give credit for time served, because they can't go into, they can't be released into the pre-release if they have pending matters, or if they have a detainer put on them to come back to our jurisdiction. So at that time, it gives the prosecution another chance to look at it to say, do we agree or disagree with that request?
Thank
If there,
you.
if
Yeah.
there isn't
Any other
any
questions?
specific questions, I was just gonna add a couple of things that Jermaine had talked about when we're using TAP. So for the judicial side, that is a tool that is used for when we talk about cases involving special tribal jurisdiction. Some of these individuals may or may not be of the community. We may or may not be familiar with who they are, their background. Small communities, you pretty much know everybody, but if you get somebody coming in because there's not that requirement of having ties to the community, you know, what are we looking at? And Jermaine gave some examples of, you know, what we find, but there are matters. If I am going to decide whether I am giving bond, bail, you know, what factors am I looking at? Those safety factors, but also, are they a flight risk? And, you know, and TAP helps with that. Okay, where are they from? You know, who are they? And do they have, will they flee to North Dakota? They have relatives over there. Will they go to Canada and won't get them back here? You know, so those things are really useful when we are looking at running people, running their backgrounds. There was another one that Jermaine didn't talk about, but utilizing TAP to run checks when people, we had individuals coming over from the Bakken, from Wilson, North Dakota. Some of them just kind of here, maybe getting into relationships, going to the bars, hanging out, whatever. But I believe that we uncovered a sex trafficking ring that was going on because we had people that came in here. It was really suspicious getting unknown individuals coming in to bond out Native females, bonding them out of their criminal charges with their drugs or even the misdemeanor charges, coming and bonding them out and not knowing who they were. So running those checks, individuals like probation, giving that information to law enforcement and saying, hey, this is suspicious. This activity seems out of the ordinary. And that's where one of the individuals was uncovered as a sex offender that was living right off the reservation in the state jurisdiction, but he wasn't registered there. So that one was encountered. They could go look into that. And then they found more information related to bank fraud and trafficking Native women. And there was a lot more that came from that, just from utilizing TAP to figure out, you know, who are these people and what are they doing here? And I kind of flew through my stuff because I wanted to make sure that we had enough time. But on the slide, I did have 3 generations of violence. So most recently, we did have it's almost 2 o'clock, so I'm gonna really hurry, but we had an outbreak of violent crimes within the past month, a lot of them involving youth. So one of the youth, we were talking to him and he was telling us, you know, he learned from his dad, that dad, you know, learned from his dad. So there was the grandpa, the dad, and the son, all of them charged with homicide, all of them committing the assault with the same technique. And it was a stab to the heart. And he was telling us how he did it, how he knew to do it, what he had learned from his dad, his grandpa, all of them in federal. And it didn't seem like anything to him, right? He was like, this is how you do it, and this is what I learned. So looking at those generational and using that with your data to try and identify, you know, where can this be most useful to us and what can we do by utilizing that data? Who do we need to focus on for that intervention, prevention type of education? And I know it's almost 2 o'clock, so thank you all.
Thank you, Judge FourStar. Thank you, Jermaine. Does anybody else have any questions? I don't want to interrupt, but. Okay, well, you all can join tomorrow's Implementing Tribes call if you would like and ask more questions. They will be on the call. And if you don't have that link, please feel free to email me at chia@tlpi.org and I can get you that link. And what did I just do? Sorry, everybody. I'm going to stop sharing this and put that slide somewhere else. Okay, well, thank you, everybody, and have a great day. And we'll talk later. Thanks so much.